The motion dated the 30th of September 2025 by the
Mr.
plaintiff
Havi.
is opposed.
The motion is opposed.
Hitherto, a defense list and bundle of documents, replying affidavit and witness statement, all dated the 7th of October 2025, have been filed. In the
A defense?
My Lord, that will interrupt with my flow of thought. Just right.
Yes, I'm writing.
Yeah.
So say it again.
Yeah. I'll speak slowly.
Yes, thank you.
A defense list and bundle of documents, witness statement, and replying affidavit, all dated
slowly.
All dated 7th October 2025.
Witness statement
and replying affidavit, all dated 7th October 2025, have been filed.
All dated
7th October 2025 have been filed.
Yes.
The defendant has taken the twin defenses of truth and justification, and fair comment.
Truth and justification.
And fair comment.
Proceed.
The principles upon which an injunction may be granted in libel or slander are elaborately laid out in Gatley on libel and slander.
The principles on which an injunction may be granted in
libel and slander are elaborately set out in Gatley's libel and slander. That is the book. The trial on this issue.
Set out in the book.
Gatley on libel and slander.
Libel and slander.
And the principles are threefold. One, the claimant must have a reputation to protect.
The principles are one.
Threefold. The claimant must have a reputation to protect.
Yes.
And two, the impugned statement attributed to the defendant
statement attributed to the defendant
must not only be untrue, but one that lowers the reputation of the claimant in the eyes of right-thinking members of the society.
In the eyes of right-thinking members of society.
And lastly, as a general rule, an injunction will not...
Just right-thinking members of society. Lastly, an injunction
will not, as a general rule, be granted at an interlocutory stage where the defense of justification or fair comment has been taken.
Defense of justification.
And fair comments have been taken. This claimant fails the first test and will highlight pre-documented evidence of his failure to comply with the first test. One, you'll find at page 156. That is the headline of the Standard on 19 September 2017 with a photograph of the claimant in a mainstream media.
The Standard newspaper
of 19 September 2017 at page 157 and 156.
2017.
Yes.
At page
156 and 157 of the bundle.
No, the page of the newspaper.
Headline, page number 1 and 2 of the Standard.
Headline of the Standard newspaper.
He's
now,
accused of having,
this is at page 1?
At page 56, 156 and 157 of my bundle.
Of the plaintiffs, of the defendants' bundle.
Bundle, yes.
Yes, proceed.
He was accused of having received a bribe on a presidential election petition. That's fact.
Accused by?
He was accused by the Standard newspaper.
Of having?
Received a bribe of 2 billion. We've not been shown a judgment that has found the Standard liable for this statement. So we go to the next set of evidence for want of repetition at page 164.
You're saying the next is the one of?
At page 164, 168, I mean.
Of the defendant's bundle.
Yes, this is the first page of the Standard of 30th August 2022. First page, headline.
Is the headline of the Standard newspaper.
And it's very bold. Isaac Lenaola received 1.7 million.
The newspaper of which date, sorry?
30th August 2022. Again, we've not been shown a judgment that has found the Star liable for the statement.
This one is Star or the Standard? The other one was Standard.
The Star. Yeah, the second one is the Star newspaper. But lastly, on that set of evidence, pages 228 to page 591.
At page
228 to 591.
228 to 591 of
the defendant's bundle.
the defendant's bundle of documents.
Allowed here, there are two affidavits filed by Victoria Keane, the daughter of the late Honorable John Keane. Affidavits on oath, where
You've
she has
taken
said,
Council, you've taken 10 minutes, so
my Lord,
you
I'll
can
be able to
budget
go
for the
fast
remaining time.
Yeah,
Yes.
I'll be able to go fast if you're not repeating after my words. If you are repeating after my words, we'll definitely take double the time.
Two affidavits
by Victoria Keane, where she has stated on oath three things. One, that Isaac Lenaola forged the will of the late John Keane. Two, that Isaac Lenaola has intermeddled in the estate of John Keane. And three, that Isaac Lenaola has influenced the litigation in respect of the estate of John Keane. So on that point, the plaintiff, Isaac Lenaola, is liable and slander proof. He has no reputation. We go to the second principle under Gatley and libel. In a judgment delivered on the 23rd of July, 2024, the impugned judgment, the plaintiff, Isaac Lenaola, states, and this you will find at page 122, for avoidance of doubt, the consent order of 4th May 1992 remains the decision of the court in the dispute between the parties. And I saw...
What are you citing, counsel?
I'm citing
page 120.
the last page of the judgment that is the subject of this dispute. That is at page 122. Because they are in my index, just allow me to go to the relevant pages without citing the case numbers.
Yes, okay. The defendant is the last page of a judgment.
Of the judgment dated 23rd July 2004 by Isaac Lenaola, which you'll find at page 122 of my bundle.
On the plaintiff's judgment. Yes.
So the question is, does that consent exist? And this is the evidence. This is the answer. You will find it at page 130 of the defendant's bundle. Here is a letter dated 7th March 2018 from the High Court of Kenya to the Director of Criminal Investigations. And this is what the letter says at the tail end.
It's a letter from
the High Court of Kenya at Nairobi to the Director of Criminal Investigation. And this is what the letter concludes.
The letter is dated. The letter is dated
7th March 2018. This is the conclusion of the letter. Please note that the original consent dated 4th May 1992 cannot be traced in our above quoted file. Consent is non-existent. Fact.
Sorry?
The consent is a non-existent, and that is fact.
Let us we are quoting. Please note that the consent.
Please note that the original consent order dated 4th May 1992 cannot be traced.
Consent order
dated 4th May 1992 cannot be traced in our above noted file. And so, what is this damnification that is projected towards the defendant? Let's go to page 149 of the defendant's bundle. 149 is a statement by Captain Kungu Muigai. And this is what he said. My challenge to the judiciary is to publish this consent judgment. A court record is a public document. Do not write long essays, just produce this phantom judgment. Phantom judgment. How can that be defamation? Produce the consent. Judge, if a judge of the High Court, Court of Appeal, or Supreme Court makes a decision on a non-existent piece of evidence, that is corruption. It's fraud. There can be no sugarcoating about it. And that's what has been said of Isaac Lenaola. The defendant has gone further. He has said he has the testimony of an employee of Kenya Commercial Bank, which he will tender at the trial to confirm receipt of 1 million as the inducement towards this impugned judgment. That
An employee of which bank?
Kenya Commercial Bank. And that he will do as day succeeds night. So let me conclude on the last point, that an injunction will not be granted where the defense of justification and fair comment have been taken.
But yes, on that point again, say it again so that I capture it.
An injunction will not be granted as a general rule where the defense of justification and fair comment have been taken. The locus classicus on this point is the case of Chesarem versus immediate services. 2 points to pick from this decision. That general principle was reiterated there. Number 2, the only reason why an injunction was given in Chesarem was because a defense had not been filed by the time the application for injunction was heard. In this case, a defense has been filed and it has been sustained with documented evidence proving the first 2 preceding principles. The second authority on this point is the case of Martha Karua versus the Standard. And because of its significance, permit me just to read the line. This is what the court said. Cases of defamation bring out a conflict between private interest and public interest. And this is more so in countries like Kenya, where we have the country's constitution which has provisions to protect fundamental rights and freedoms of the individual, including the protection of freedom of expression. Hook, line, and sinker. The third case is the case of Nyachai versus Lazarus Ratemo Musa and another. And this is what the court said. The threshold, in my view, is that the courts should not fall to the trap laid by the politicians and powerful to restrict the development and progress of press freedom. Politicians and powerful. A judge of the Supreme Court is a powerful person. We are told that
that court should not.
The court should not fall to the trap laid by the politicians and powerful. Politicians and powerful to restrict the development and progress of press freedom.
To restrict the development
and progress of press freedom.
Of press freedom.
Yes. Lastly, my lord, the case on point of this issue is Johnson Sakaja versus Nation Media Group PLC and two others. And you are, my lord, this is what you said in this decision at paragraph 20 of your ruling. In the pretrial period, a rolling gag order such as the one the plaintiff is seeking in this motion is most undesirable. Most undesirable.
That again? That
in the pretrial period, a rolling gag order such as the one the plaintiff is seeking in this motion is most undesirable.
okay.
Judge, we've been told that these are exceptional circumstances because the plaintiff is a distinguished judge and a judge of the Supreme Court. Those cannot be exceptional circumstances because of two reasons. A judge of the Supreme Court, Philip Tunoi, has been removed because of corruption. It's not exceptional. Number two, both the judiciary and the Law Society of Kenya have admitted that corruption in the judiciary is a menace. The admission by the Law Society of Kenya is contained in the statement dated 18th December 2024. It's actually a memorandum by the President to the Chief Justice. And I've highlighted the relevant part at page 186. This is what the President of the Law Society of Kenya says. The most glaring form of judicial misconduct has to be corruption. Instead of justice and truth being weighed against evidence, it is traded and auctioned to the highest bidder in total disregard to the rule of law and constitutional principles. It is traded and auctioned to the highest bidder. That is the complaint by Captain Kumu Mwegai. Let us see what the Chief Justice said. In our end of year message dated 31st December 2024, which you'll find at page 206 to 207, this is what the Chief Justice said.
In Howard? in her end of
year message, read on 31st December 2024, this is what the Chief Justice of the Republic of Kenya said. At page 206, I've highlighted it in red, last paragraph, 206. Judicial accountability, as demanded by the Constitution, requires a whole of society approach. Corruption within the judiciary cannot exist independently of corruption within the legal profession or broader society. The legal profession is corrupt. That's an admitted fact. We have corrupt judges. That's a fact. Judge, there are many other judges who are not corrupt. Let the judges who are suspected of corruption not use the court process to stifle, curtail, and gag victims who are here to complain. Isaac Lenaola is one of those judges. I beseech you to dismiss this application for injunction. Thank you so much, Judge.
Okay, that is it. Mr. Omiti, when it comes to highlighting, because each party is highlighting the submissions, there's no right of rejoinder, because you are basically highlighting your own submissions.
That's correct, Manod. I think there's just one or two issues that have arisen that I would wish to respond to, if you allow, Manod.
Everything that both of you have stated, I will glean those in your respective submissions.
All right.
In the event that I find anything that any one of you has said in highlighting, which is not in the submissions, I will disregard it. Yeah. Thank you. So let me give you a date for ruling. Yes.
29th of January. 29th of January.
Give me a date next month.
Next month. Okay.
Yes. Before we go on the vacation. The last week
18th of December. 18th of December.
Yes, ruling on 18th of December 2025. Interim orders are extended.
We are most obliged, Judge.
Much
Thank you so
obliged.
much. Have a good day. My colleague will meet you as well.